Okay, John Simpson has practiced law in Washington, D.C. office for more than 34 years. Another Harvard guy, a graduate of Harvard College, where he was a member of the Harvard varsity football team and former infantry officer in the U.S. Marine Corps. Mr. Simpson attended Columbia Law School, where he was a Harlan Fiske Stone Scholar and articles editor of the Columbia Journal of Transnational Law. Mr. Simpson has been a partner since 1986 and is currently the partner in charge of the Washington litigation practice, managing a group of more than 40 partners, associates, and other timekeepers. He also supervises the Washington office program that provides courtroom experience to young litigation attorneys in their handling of cases pro bono for the District of Columbia government as a special assistant attorneys general.
I don't have a PowerPoint today, and it's not because I'm lazy. It's because if I made one, I'd have to produce it in discovery in the case I'm handling. I want to talk today about the case it's actually two cases, but the case that I've been working on for Feld Entertainment since 2005, actually, pending in a federal court in Washington, D.C. I appreciate the comments of Professor Tenenbaum, and I know it's a very complex subject, but just for on a personal note, from my own perspective, with respect to animal rights, I just read this one statement. And God said, "Let us make man in our image, after our likeness, and let them have dominion over the fish of the sea, and over the fowl of the air, and over the cattle, and over all the earth, and over every creeping thing that creepeth upon the earth." I know it's more complex than that, but it's good enough for me. Genesis 1:26, King James Version. This case, let me just give you a little background on this case. I've been representing Feld Entertainment, which is the company that owns and operates the Ringling Brothers Circus, since 1990. My law firm, in one form or another, has represented this company since 1950, when they actually engaged or represented the Feld family in a purchase, or Irvin Feld in a purchase of the company with Roy Hoffines, who built the Houston Astrodome, from John Ringling North. This is a family-owned business. This is a business that produces family entertainment. So these are not people that come in, make a killing, do a leverage buyout, and then leave. These are people who run this business because it's part of their very being. And it's part of their very being that they run this circus. And the hallmark of the Ringling Brothers Barnum and Bailey Circus is the Asian elephant. Period. That's the hallmark. They have other acts. They've had cats. They've had bears. They've had porcupines. The Asian elephant is the hallmark of the show. This operation is older than Major League Baseball. And they have had an Asian elephant featured in a show for 140 plus years. Now, it's precisely because of that they are what the professor refers to as a marginal defendant. And so the people who are against animals in entertainment, against elephants in entertainment, elephants in a circus, whatever you want to call it, decided this was a good target. Precisely because it is Ringling Brothers, not because it's some other circus, Joe's Roadside Circus. It's because it is Ringling Brothers and everyone has heard of them. And so they picked this lawsuit to bring this case. And what they challenged were two indispensable tools for managing Asian elephants in what's called free contact, in a free contact environment, in which the handler is in the same space with the animal, as opposed to protected contact, which is what the animal rights people will tell you need to do, where the only interaction between the human and the elephant is through a barrier. Okay? Direct contact, free contact, requires that the human being be in control of the animal. And the way that has been done for 4,000 years with Asian elephants is with an instrument called the guide, the ankus, the bull hook, the stick. It's got a number of different names. It's got a point and a hook. And the basic object of this is to teach the elephant what you want her to do. You give her a command. If she doesn't respond, you guide her with this instrument. And it is no more harmful on this elephant than it is to put a leash on a dog. And and it's as my colleague pointed out, the anthropomorphism. Every time I've been to one of these arguments, one of these cases, the first thing they do is they get that bullhook out and they say, ooh, it hurts my hand. Well, yeah, it hurts your hand, but an elephant's got hide that's that thick. We had an autopsy or a necropsy photograph of elephant hide in the trial. It's an inch thick. They're called pachyderms for a reason. We didn't invent that term. They're called that for a reason. So they attack that tool. They also attack the use by the company of chains. Politically correct term, tethers. They're chains. They're tethered with chains. Why are they tethered with chains when they're transported? For the same reason you wear a seatbelt when you drive a car. That's the same reason. Why are they tethered at night? Because if you don't tether them at night, they don't go to sleep. Just like your children. You put a 3-year-old in the crib and you leave the thing down, he's going to get out. Same thing. You got to have control over the animals. So yes, they're controlled, they're disciplined, but the company made no apologies for that. But if you attack those two instruments, then you have basically attacked the very existence of the show, because without those two instruments, you cannot travel. You can't do it. It's not safe. They may be able to come up with something as an alternative, but it hadn't been thought of yet. So if you enjoin those two tools, then you can't have a traveling circus with elephants in it. Of course, the animal rights people said, well, we're not against the circus. But that's like saying we're not against baseball. We're just against the bats and the balls. It's the same concept. So that was their motivation, because they wanted not to, it had nothing to do with animal welfare. In fact, when we inspected these elephants in the case, in a formal inspection on videotape, one of their so-called experts turned to the handler and says, it's obvious you love these elephants. We got her saying that on tape. So it wasn't about welfare. It wasn't about abuse. And one thing I learned when I got into this case, and I didn't know anything about elephants before this case, is that the folks at Ringling Brothers, Feld Entertainment, they are the people who set the standards in the world for caring for Asian elephants. It's that simple. And as well as one of our expert witnesses, Carrie Johnson, same thing. And when you interact with these people, you realize they love these elephants just like their children. And one of the most poignant points in this trial was when, and I can't remember if we were asking the question or the other side was, but they asked Carrie about the death of one of her elephants, one of her baby elephants. And she actually came to tears. And you could see the emotion. And that had a major impact on that judge. It had a major impact on that judge. Because accusing these people of abuse is like accusing a kindergarten teacher of child abuse. It's offensive, and it makes you want to fight. And that's exactly what happened. They picked the wrong marginal defendant. So they bring this case, and it's based on a theory that has never been tested in court before. They're saying that because the Asian elephants are endangered, this conduct, this use of the guide, this use of tethers is a, quote, take. These elephants are being taken, which is ludicrous, because taking has never meant in the United States anything more than taking wild animals out of the wild, reducing them to human possession. What Congress did when it passed the ESA was prohibited taking domestic species like bald eagles and engaging in the trafficking of endangered species. That provision had never been applied to an animal already in captivity, being just managed with normal husbandry techniques. Why? Because the Animal Welfare Act already covered all that. There was no reason for that. But they brought this case because they knew that the literal definition of take, which prohibits any kind of wound or any kind of harassing of an endangered species, is illegal. Well, how do you have an elephant in captivity if you don't have the ability to do foot care, to give hypodermic injections? All of that would be a, quote, wound, and they knew that. And they knew that the judge bought that ridiculous theory that they could enjoin the use of this guide and therefore enjoin the circus. But in order to get into court in this country, particularly in federal court, you have to have what's called standing. Standing is a very complex concept. Most lawyers don't really understand it. But what it really boils down to is that you can't just come into court and say, I don't like what's going on, do something about it. You got to be injured by it. In some way, you've got to be injured. The most obvious injury, you get hit by somebody, you break your leg, you come into court, he broke my leg, it was negligent, give me money. Clear-cut cases of standing. But if you're someone who's griping about how somebody else treats their elephants, which is their property, none of your business, how do you get into court? Well, the first argument was A former barn man that worked for the company had an aesthetic injury because when he was there, they used to beat these elephants all the time, according to him. He couldn't stand it. That's why he quit. And therefore, if you stop beating them or put them in a sanctuary, I'll go back and visit them. So that was their theory, right? Aesthetic injury. It's a recognized theory. It's recognized by the Supreme Court of the United States. Aesthetic interests are protected, but they're highly subjective. It's very hard to give you can't give someone, for example, a blood test to see if they have an aesthetic injury. You can't give them an x-ray. They're either credible or they're not. Well, so the whole case goes forward based on this guy's claim that he's aesthetically injured. The organizations in the case, the ASPCA, the Animal Welfare Institute, the Fund for Animals, Animal Protection Institute, now known as Born Free, they had what's called an organizational injury. And it gets complicated, but the basic point is they spend their resources advocating against elephants in entertainment, and therefore, if the elephants were not in entertainment, we wouldn't spend those resources. So if you enjoin this, then you resolve our injury, our resource injury. You know, it's another flaky theory of standing. All right, so this case goes forward. Gets filed in July of 2000. Law firm at the time wasn't me. Comes in, moves to dismiss. Motion granted. Out. Nobody's got standing. This is ridiculous. Goes up to the D.C. Circuit, our appellate court, where they basically continued this false statement about this man having this aesthetic injury. They say, well, if that's proven, if that turns out to be true, then he's got standing. We don't care about the other organization. They get to ride his coattails. So that goes back down in 2002. At that point, this company spent maybe $200,000 in legal fees. But because the standing issue turns on this man's credibility, the only way in our system credibility of witness is ever resolved is through a trial. So now my client has to walk the coals through all of the pretrial stuff that goes with one of these cases. The discovery, the pretrial motions, the elephant inspection we had to do. We have to go through, from that point forward, another 6 years of litigation to get this case to trial, which means we got to come into court. We got to be ready to deal with all of their stuff. We got to have our own expert witnesses. We have to have our own company witnesses. You got to do all that work to get, and then you have to put on your evidence. But what happens at the end of the trial? The judge, this guy gets on the stand, this former barn man who had the aesthetic injury, and the judge finds his testimony totally incredible. And why is that? Because he's a liar. And he's not only a liar, he's being paid. Comes out in the discovery, he's been paid over a period of 9 years, $190,000 by the organizations and by the lawyers handling the case. They paid him through their own law firm. Okay? But it's not just the money. The money's gross enough. But this idiot goes out, he goes to the, we first of all find out he's not staying away from the elephants. He's in fact going to see them. And they're paying him to go see them, and they're paying him to go see them and make videotapes. So he goes to one of the train unloadings and looks through the window with this camera, and it has an audio feature, and he films the elephant in there. And of course, he's trying to get poop on the floor, but what he gets is poop in a bag. They've already cleaned it up because that's what they do. They don't stand in the poop, which is another urban legend, but they needed video of that. So number one, he doesn't get the visual they want, but then he's commentating. He's talking to himself, and he calls this elephant, who's one of his girls that he loves, a bitch. That's what he said. Hey, Karen, you bitch. And I thought, did I hear that right? I had to hear that 3 times. And so when this guy takes the stand, that's like one of dozens of instances where he had said and done something inconsistent with what he had done in the past. When that came out, the judge's eyes got that as big as saucers. And he said, wait a minute, isn't this the elephant, one of your girls? Do you regard that as a term of endearment? He said, oh yeah, I call my daughter that all the time. I mean, so he goes up in flames, and the judge turns to the organization, and it's interesting because the organizations, there were 4 of them. There were 4 of them. 3 of them abandoned the case in the middle of the trial. They don't want any, no, we just want to be here. We don't want an injunction. Just don't give us any relief. We started out with an injunction. That's what they wanted. They wanted to shut it down. Because they came in there all high and mighty about how this is like the Tellico Dam. If you have snail darters, you've got to shut down the damn dam, right? And no, they backed totally away from that because they knew when they went out and did this on the courthouse steps, they were getting major pushback in the media. You're really trying to shut the circus down? Oh, no, we're not. They knew they had to come up with some, in-between remedy. So we don't want an injunction. We just want you to order them to go get a permit, which is absurd because the company already had permits. And if you're so injured by this, then why do you want the federal government to give the company a permit to do this for the next 100 years? It makes no sense. So it's an idiotic theory. So he says, Ryder, that's the plaintiff, you're unbelievable, you're paid, you're out, the organization has no cognizable standing, so I don't even need to reach the merits. The whole case is gone. This is December 30, 2009. $200,000 the first time. By that point in time, $19 million in legal fees. So we go up to the D.C. Circuit, same court that dealt with it the first time, same result. Ryder's got no standing, the organization's got no standing. So Feld Entertainment went through 12 years of litigation, tried to get rid of it up front. No, they lied. They go to the Court of Appeals. The lies are shown at trial. And we end up winning on exactly the same grounds that we did the first time. So we decided, since the Endangered Species Act says prevailing parties get legal fees, to put in a claim. Now, you got to remember, in this, it is what it is. Plaintiff wins a case like this, plaintiff generally gets legal fees. Big bad defendant, however, wins a case, not so much. You got to show that the case, not only did you win it, but it was frivolous and vexatious. Hard standard, very hard standard to prove. So hard that no one in the history of this statute had ever proven it. And this statute was passed on December 28, 1973. Nobody had ever done that. And even in the civil rights area, where the same standard applies, very few defendants ever get legal fees. And the reason for that is Congress has said we don't want to chill people from bringing legitimate cases that are close calls because on pain of maybe having to pay the defendant's legal fees. But what we don't want people doing is bringing frivolous cases, vexatious cases. So we put in a claim for this. The judge ruled after a year, it sat there for a year after thorough deliberation, that this case, the standing theories in this case were frivolous and vexatious from the beginning. This case was unreasonable from the beginning. This case never should have been brought. This case lasted as long as it did because of the plaintiff's conduct. Judge's words, not my words. The judge's words. And that came out on March 29, 2013. That's the first time in the history of this statute that a non-governmental defendant's ever recovered fees against a private plaintiff. So we put our bills in, and we just filed this. We filed our so-called fee petition on October 21st, and the claim is $25.4 million. Now, that represents, there's an enhancement in there for the time value of money because some of these legal fees were paid in 13 years ago. And you say that's a lot of work. It was a lot of work. It's like 49,000 hours of lawyer time. But over 13 years, that's basically 2 lawyers working full time. And this case was litigated at every single turn. But what's more important, that $25 million could have taken care of Feld's elephants as a group for almost 9 years. They spend about $62,000 a year on each animal. Had this case been lost, of course, the elephants are not, you're going to see it, in a traveling show, forget that. So that's gone, that's history. But what's probably more important is without free contact handling, and the veterinarians debate this, but our view is without free contact handling, you don't have optimal vet care and you don't have the optimal scenario for breeding these animals in captivity. The Ringling Brothers Barnum and Bailey Center for Elephant Conservation, which is right up the road here in Polk County, is the most successful breeding project in North America, bar none. They They set this up in the middle 1990s. By the time we tried this case in March of 2009, they'd had 22 successful captive Asian births, or 22 births. They've had 4 since then. They've got some elephants that are third generation born in captivity. It's been recognized by the federal government as a sustaining population, which means they will sustain themselves. And at the end of the day, you shut that down, what do? You basically promote extinction, which is the ultimate irony, because an Endangered Species Act claim is, the Endangered Species Act is an anti-extinction statute. So if these people had been successful, they would promote extinction of the species. Because make no mistake about this, if you don't have companies like Feld doing what they do, the Asian elephant will be extinct in 50 years. That is an inescapable fact. There are 450 to 500,000 African elephants in the world. There are fewer than 35,000 Asian elephants. And the Asian elephant is in that part of the world that is the most pressed by human expansion. So we were in a federal court in Washington worrying about whether some elephant got stuck with a stick that was no more significant than a little fly bite. But every year in India, they get hit by trains, they get poisoned, they get electrocuted, hundreds of them. So if you don't have this kind of thing going on by a company like Feld Entertainment, which, by the way, only exhibits maybe 25% of the animals. A lot of these elephants never go on the road. They're never exhibited. They're just there. They're doing their elephant thing. That's what they do. So that's what we averted. Now, in addition, because of this money situation with Ryder, the witness, we brought a lawsuit against this same group of organizations and the council on the ground that you paid this guy over 9 years. He lied at trial. Therefore, you engaged in a pattern of bribery and violated the RICO statute. Right? We filed that lawsuit in 2007, and the judge stayed it pending the outcome of the other case. But once we won the other case, we filed a First Amendment complaint, added the lawyers and the Humane Society of the United States. Because in 2005, as you all know, they acquired, we say, they deny this, they acquired the Fund for Animals. So our view is that you're up to this in your eyeballs. Well, they got all, in addition to the RICO claim, which, by the way, under federal RICO law, you get legal fees if you win. They get nothing if they win. But you get treble damages. So in the RICO case, our theory is if you hadn't lied, and if this guy hadn't been paid to lie, this case never would have existed. This company never would have paid these legal fees. Our damages in the RICO case are our legal fees. So that's $25 million times 3. That's $25 million times 3. We also sued them under the Virginia Conspiracy Act, which has a similar remedy, which is a little depth charge waiting to go off. 25% of the animals. A lot of these elephants never go on the road. They're never exhibited. They're just there. They're doing their elephant thing. That's what they do. So that's what we averted. Now, in addition, because of this money situation with Ryder, the witness, we brought a lawsuit against this same group of organizations and the council on the ground that you paid this guy over 9 years. He lied at trial. Therefore, you engaged in a pattern of bribery and violated the RICO statute. Right? We filed that lawsuit in 2007, and the judge stayed it pending the outcome of the other case. But once we won the other case, we filed a First Amendment complaint, added the lawyers and the Humane Society of the United States. Because in 2005, as you all know, they acquired, we say, they deny this, they acquired the Fund for Animals. So our view is that you're up to this in your eyeballs. Well, they got all, in addition to the RICO claim, which, by the way, under federal RICO law, you get legal fees if you win. They get nothing if they win. But you get treble damages. So in the RICO case, our theory is if you hadn't lied, and if this guy hadn't been paid to lie, this case never would have existed. This company never would have paid these legal fees. Our damages in the RICO case are our legal fees. So that's $25 million times 3. That's 25 million times 3. We also sued them under the Virginia Conspiracy Act, which has a similar remedy, which is a little depth charge waiting to go off, and then malicious prosecution and abuse of process. They moved to dismiss this case. The judge denied it in July of 2012. So now we're in the middle of discovery in this racketeering case. In the meantime, in November of 2012, the ASPCA came knocking on the door, and they wanted out. And they got out. But they had to pay $9.3 million to get out. And I want to emphasize something. There was a lot of sturm and drang in the media when they made that payment about, ooh, this is terrible. You know, ooh, think of all the dogs that won't get cared for and this and that. Forget about it. Forget about it. When they started January 1st, 2012, the ASPCA had $182 million in net assets. They made that payment to us in a single wire transfer lump sum payment on December 21st, 2012. At the end of the year, they had net assets of $185 million. So they not only paid the $9.3 in cash, their net assets went up $3 million that year. So they had the money. Humane Society of the United States, consolidated financial statement for 2012, shows net assets of $215 million. That's up from the previous year by $15 million. That's pretty good in a down economy. So one thing to always keep in your mind is that these people are very well financed. They claim that this is all the charitable work, they're doing the Lord's work, but they are no different than a for-profit business. They just pretend to be charities. That's all it is. And somebody sent me an email once that he'd gotten from Wayne Pacelli. I'd never seen this before. Pacelli's email address actually had a donate link on it. I'd never seen that. But you know, just in email traffic, just donate, go ahead and donate. It's ludicrous, but they're driven by the dollar. Our company is a for-profit company, but we don't apologize for that. But they keep the charade up. But that's critical because there's nothing anywhere near nothing comparable to this on your side of the ball that I can think of. Nothing. And it's unfortunate because this is their business. Making your life miserable is their business. Pursuing their agenda is their business. But you've got a business to run. You've got to either run a circus or run a farm or breed dogs or whatever it is you do. And then you got to, on your spare time, deal with all this other stuff. And that's hard, you know. And you can see, I've seen the emotion. I've seen how this wears on these people. These elephant handlers, to be spit on in public, to be yelled at, to be called all kinds of profane names. I've had my life threatened. You know, we've sent all this to the FBI. They can't do anything about it. But you're dealing with people that have a mindset that's it's just not rational. It's just not rational because they don't want you to they don't want you to do anything that would inconvenience an animal in any way. It just doesn't matter. It doesn't matter what it is. And if you don't agree with them, you know, then you're, too bad. But one thing I think that I think I did learn in this, and we're not done, obviously. This case continues. But one thing is if you have you have to have a focused mission, whatever it is. You have to be focused, but you also have to have faith. You also have to have faith because what I realized, and I didn't, when I come back to what I started with, I didn't know anything about elephants. For all I knew, I was getting into something that was bad, and maybe these were bad people. Who knows? I mean, I saw the videos of them, what they want you to see. Some guy with a tattoo. I mean, so Lord knows what I was getting into. But once I went out and saw it and interacted with these people, you realize that they treat these animals just like their children. In fact, maybe better than their children. Certainly, the elephants from the Feld people are always first. Whatever it is, they are put first, ahead of everything else in terms of care and priority. Ahead of, it's a hard job. It's a 24/7 commitment, particularly on the road. It's miserable. And it'd be miserable even in the 1950s when nobody's protesting you. But now what you got every place you go, people are trying to stop you or spit on you or protest what you do. It's bad. But by seeing that and being uplifted by that, it convinces me that regardless of the odds, the good guys are going to win. The good guys are going to win. So I'll get down off my soapbox and can answer any questions you might have.
We'll take a couple questions, and then we'll take a break, and then come back for Dr. Waters. So...
All right, it's the $75 million in lawyers' fees, you said, or $25 million?
The claim for legal fees is $25.4 million through March 30, 2013.
So does the ticket keep rolling?
It keeps rolling because having been ruled that we're entitled to recover, we get what's called fees on fees.
Good.
So the longer they drag this out, the bigger the tab's going to be.
So is the main organization HSUS that will have to pay this?
We think so.
Okay.
We think they're going to be required. Yes, ma'am. I don't know. I mean, I know about the ruling. I've not been, involved in that. I just know this, though, that this family is committed to the Asian elephant in the circus. So we'll find a way to deal with it, believe me.
Is there anything that Feld needs us to do, or members of the public? Is there anything we can do to help you?
Well, if you get your checkbook out. No, I'm just kidding. Just kidding. What's interesting, and I was just doing my job handling a single case, but when we got that original judgment in December of '09, I got calls from people all over the country that I didn't even know existed, saying, this is great. This is the first time this has ever happened. I got that from some rodeo person in Nevada, and then a horse person in Michigan, and dog breeders all over the state of Florida. So I think what I would say, continue to do what you do. Meetings like this are vital. If you just raise one person's consciousness, you've accomplished something. Because ultimately the American public is going to be on your side. The American public loves the Ringling Brothers Circus. And they want to hear the debate, but they also ultimately want to know, well, how are they really treated? And those elephants, if they were really being abused, you think they would live longer than any elephant anywhere? The average life of a Ringling Brothers elephant is between 55 and 60 years. The average life of an African elephant right now is 45 years. So the idyllic wild isn't so idyllic. Yes, ma'am.
Legal action being taken against the guy that perjured himself? Because if he's made an example that might discourage other people from...
He's a defendant. Well, two answers. Number one, he was made a defendant in the RICO case, but he died on October 1st. So here's what it is. Interestingly enough, he was 63. He's 1 month younger than me. I'm 63. Two of the elephants that he was allegedly attached to, still alive.